The case that I chose this week is case study 8.3, which is Franklin versus Gwinnett County Public Schools in the U.S. District Court in the 11th Circuit in Georgia, and this case occurred in 1992. This case specifically deals with Title IX, and the petitioner is Christine Franklin, and Christine was a student at the North Gwinnett High School in Gwinnett County, Georgia, between September of 1985 and August of 1989. The respondent was the Gwinnett County Public School District, which operated the high school that Franklin attended, and this school district receives federal funds, which is going to play into the lack of reward that Franklin received for the alleged harassment in this case. A complaint was filed on December 29, 1988 in the United States District Court for the Northern District of Georgia in the 11th Circuit. Franklin was subject to continued sexual harassment in the fall of her 10th grade year, which occurred in 1986. Andrew Hill was a sports coach and a teacher that was employed by the school district at this time, and Hill was the alleged abuser in Franklin's complaint. Franklin's complaint states that students, teachers, and administrators took no action to end the abuse that was going on, even after they became aware of it. They even went as far as to try to convince Franklin into not pressing charges against Hill. In April of 1988, Hill resigned contingent on the condition that the charges and case be dropped when he did so. Because of this, the school closed their investigation of Hill, and the district court dismissed the complaint, stating that Title IX does not authorize an award for damages. The Court of Appeals affirmed this decision. However, this decision conflicts with a decision made by the Court of Appeals in the Third Circuit, and because of this, the case was granted certiorari, which means a reverse. The case in the Third Division that was in question in regards to Franklin's case was Cannon versus the University of Chicago, and this case stated that Title IX is enforceable through right of action. So by Franklin filing this complaint and for the sexual harassment that was going on against her, she had a right of action that needed to be looked at and needed to be tried fairly. In the Franklin case, it must be decided what remedies are available in a suit that is pursuant to this implied right. So just because she brought these charges to the court doesn't necessarily mean that she'll receive a monetary award or that Mr. Hill will receive any type of judgment or jail time or anything of that nature. Everything is pursuant to each case. When legal rights have been invaded and a federal statute provides for a general right to sue for such invasion, federal courts may use any available remedy to make good the wrong done. Several past cases were taken into account before the court's decision was made regarding whether the case could move forward or not in the Court of Appeals. Because of this, instances of monetary award and other harsh repercussions for Hill were discussed and talked about whether or not the decisions were going to be applicable to this case. Justice Byron R. White was the author of the court's unanimous decision regarding the matter, and the court decided that monetary damages are available under Title IX because of the supposition that relief is available to remedy a violation of federal right. Monetary damages under the Title IX Act, however, are limited to back pay and eventual relief struggles. Because of this, Franklin really wasn't going to receive any money or compensation for that matter because she was not employed by the school. Therefore, they cannot give her any back pay. She was a student at the time that the harassment occurred, and she's also no longer a student now that the decision has been made, so there's really no solution that they can come to that would compensate her fairly. When causes of action are applied judicially, the right to do is to involve limitations on the remedy for those actions. Again, since Franklin was a student, back pay is essentially useless to her, is what the preceding statement means. There are several implications for the athletic director in this case, such as students are going to be less likely to participate in sports if the program is seen to be unsafe. If someone's scared that they're going to be harassed in any type of way, they're going to be less likely to want to play sports for a school or for a specific program. Even if the student is deciding that they want to play and they're going to put their safety at risk, a lot of parents are not going to allow their students to participate in sports at a program that is considered unsafe and doesn't look out for the student. Morality and good character are also on the line when something is known about and not reported. So especially if the staff is trying to convince someone not to press charges for a harassment or abuse that has occurred. Because of this, if you're trying to teach your athletes and the others in your program good character traits and give them a good sense of morality, if you're going against something completely in this nature, then you're going to be teaching them the wrong way to handle things and the wrong way to handle hard situations. In the future, the athletic director needs to take the steps necessary to help the student and all students in the program feel at ease. Some ways that he could have done this would be through firing the coach, talking to the staff about the proper way of reporting things, and even telling the staff not to convince students to not press charges. If the AD abides by these standards, not only will he or she help the student feel safe and secure, but the environment will be safe for all students and the school could avoid a lawsuit altogether.